Okay, we're going to go straight into questions. We've had three speakers talking about the situation in Ireland in terms of constitutional challenges, separation of powers, the 10 years in which we really had a bit of an inkling to what ESC rights might see in terms of justiciability, and then looking at some foreign jurisdictions. We had the discussion in terms of the international framework firstly, and then we had the whole question of austerity and looking at some of those Hungarian, Latvian and German decisions showing what is possible, what might be possible, looking process rather than content approach to having a constitutional framework. And then lastly, we had the whole question about healthcare access to, whether it be a constitutional level or a legislative level, if on a legislative level, how that would take place, and some possibilities for the future as well. So we might take questions. I take two or three together, and then we go around the panel. And if you wouldn't mind just introducing yourself if you're from an organisation as well. Thanks.
Thank you. My name is Lorna Rowe. I'm a Social Policy Officer within Age Action Ireland. I've worked with Ros before in the UPR process. We were providing some of the evidence from Ireland and some of the issues around austerity and older people. So it's been really interesting. I've been following Ros's work within Amnesty and the campaign that they're doing around the right to healthcare, and then obviously looking at the Constitutional Convention. And I've always been giving Ros some questions around this, not coming from the background, a legal background, and she's been very informative for Age Action anyway, in terms of looking at what we can ask for within the Constitutional Convention. But one of the things that I was wondering from this presentation, from the three presenters actually, in discussing things that the courts can do with regard to economic, social and cultural rights, are they framed within the context, within the national context? So if you're looking at housing rights and a decision to be made, and there's a budget to be for that decision to be made within, are you also going to look at the fairness and progressivity of tax law within that country? And can the courts make a decision based on that? So for example, if you have one of the South African decisions around housing, but you have, say for example, a very low tax take within South Africa, can the court say, we require that you have more progressive taxation in which to fulfill your obligation to provide or take the necessary steps to provide people with housing? And if you could comment on that as well within the Irish context, that would be really great.
Thank you. Do we have someone else? Here we are.
Hi, my name is Roisin Ryder. I'm from the community group Fatima Groups United, and I coordinate the health project there. I suppose I'm just interested in the breadth of primary care and just the framing. I haven't completely articulated the question in my head, but it's something around, we work from a community development approach to health, which is a non-medical approach. And I suppose my fear around the whole legislation and everything is people often just see healthcare in terms of medical response to an illness. And I know there was a sort of a push on, which I would completely support, obviously, free access to GPs, free access to hospitals. But there also is something about people having a sense of well-being and control over the health, and then the fact that we would work from the social determinants of health, which means that there's a whole spectrum of issues that affect people's health, unemployment, housing and everything. And I'm just wondering about the breadth of that within healthcare and framing it in legislation or in the constitution. Can that be taken into account? And very, very interested in the whole monitoring of it too, and how that would be done.
Okay, thank you. Would we have one more? Just to round it up, thank you.
Hello? Oh, good. My question is kind of just about Article 45, and is there any way that we could review legislation by using Article 45? I know the Indian example where they pretty much lifted our entire wording of our directive principles, but then they went much further with it in that they took the middle road of kind of using the directive principles to inform their interpretation of other articles of the Constitution. And I was just wondering, is there any bar for the judges in Ireland for doing something similar, apart from just their own reluctance of doing something so creative? Is there any kind of constitutional bar in the Irish Constitution that would prevent them from using the social principles policies to kind of inform their way they interpret the other articles of the Constitution.
Okay, thank you very much. So we have 3 questions, and we'll go down each of our panels. The first one is, could the courts look at the question of fairness of tax in the context of housing rights, in terms of taking steps? We're talking about sort of relief, declarations, mandamus. The second question was looking beyond legislation at the social determinants of health. The question was, how would you frame that in terms of legislation or the Constitution, and what question of monitoring? Obviously, the ESCR comes in there. And the third question was Article 45. Are the separation of powers elevated to a religion, or is there more structural way in terms of international experience?
To deal with the last question first, very briefly, there is a bar to it, because Article 45, it says not cognizable by any court under any provision of the Constitution. So the preamble to Article 45 actually precludes the kind of harmonious interpretation you're talking about. Having said that, the court still did it in Murta Properties versus Cleary when they recognised the right to earn a living. But it's generally accepted that flew in the face of the plain text of the provision. So that's a quick answer to that one. The question on tax policy came up in Ireland in the Senate case, Senate Minister for Education, when Justice Barr made the comment that the state had an obligation to meet its constitutional obligations, even if that necessitated the raising of additional tax. And he said, happily, that's a situation that hadn't pertained in recent years. Now, whether it's unclear whether that aspect of his decision was actually overturned by the Supreme Court or not. They didn't really address it in the Supreme Court decision. But I suppose, especially in the current context, it's difficult to see an Irish court getting into, and especially difficult to see the current Supreme Court getting into the detail of taxation policy. I couldn't see them involving themselves in that level of detail. But whether they would indirectly, and this came up also in the South African cases, in the Treatment Action Campaign case, when the court also said that even if additional resources would have to be found to vindicate the right, well, then the government would have to do that. But I think any such interference would be likely to take the form of saying you must adopt this policy, and then whatever you need to do with tax to make that happen is you need to do it. But we're not going to go for, they might set out the policy on healthcare, education, housing, but not get to the level of setting out the necessary tax policy to follow through on that, would be my feeling.
I'm just going to address the second question and pick up where Conor left off. What I'd say is, if you look at, say, there's cases that have been taken with regards to provision of a right to adequate education in the US at a state level, so not the federal level. And there you've seen courts literally, on the basis of findings by expert panels that the court asked to do research on this, specifying exactly how much money needs to go, for instance, needs to be paid by a particular district towards certain specific budget lines. But it's interesting that even there they don't get involved, even though they're prepared to order specific amounts of money that need to be allocated towards, say, adequate education. They don't get involved in detail with saying how that money is to be gathered by the state, or it's to be found by the state. So just to echo what Conor was saying, and saying that while what he says is true about South Africa, I can't think of a jurisdiction in which the courts have turned around and said, and this is what you have to do, and this is how you're going to fund it by amending such and such an aspect of the tax system.
Thank you. I might just touch on a couple of things. Roisin, I think you make a good point around that kind of the social determinants of health, but it's also not just healthcare. And I'm very careful to say that while our focus has been around equal access to healthcare, and even the work around mental health, and particularly some of the work around community-based mental health services, is about care. That's not for a moment suggesting that that's all there is to the right to health. But I think there's also a point that that's where we can't take these rights in individually necessarily, that that they're so indivisible that actually in some ways you'd be looking at the adequate standard of living plus the right to health plus the right to education in terms of some of the social determinants issues. But it also goes back to that point in terms of government measuring the impact that a particular cut will have, and identifying which groups are affected by that. And that probably would allow for there's multiple identities, so it's women in particular, urban versus rural areas of a particular age are impacted by that cut, but that requires good data gathering, and we're really bad at data. I mean, it's the least sexy part of human rights, but monitoring, but it's critical, and it's critical to effective government policy. I think that's where actually some of the monitoring work, and I know Des flagged the reporting to the Committee on Economic, Social and Cultural Rights, but that's probably one of the next big hits in Ireland on the international stage. How do we bring forward the data to show the impact of cuts in terms of the outcomes that you're very familiar with the communities you're working with? Also just wanted to touch on something that Lorna was saying. There's a big question here around how transparent are we in terms of what's actually being delivered with the money that is going into Exchequer funds. There's a really interesting private members bill being brought forward just now by Owen Murphy, the Fiscal Transparency Bill, and it's saying that each one of us as a taxpayer will get an account of you've paid this much in tax this year, and X amount of that went to the universal social charge and X went to general Exchequer coffers. What's the next step in that in terms of what's delivered with that money? In some ways, maybe with health, we can see it more clearly where there may be points of ring-fenced funding, but some sense of what level of expenditure is going to social services that would then allow for some assessment of the level of expenditure in that area and then the outcomes, and involve the public in that debate in some ways, because I'm sure we don't necessarily all have a good sense of exactly where's my tax money going, and I think that's critical in terms of the public debate around what services are being delivered by government as part of the delivery of their human rights obligations.
Thanks, Conor. Well, I think we're in the main room here. They're on the other room, so they haven't come in yet, so we can still keep going with a few questions until they barge in. Liam?
Thank you, Liam Thornton, UCD. Just two very quick questions. One, and it might be going back to what was discussed earlier on, are we basically ignoring the great resistance from politics, and in particular the public? Because Ignacio mentioned that, you know, the approach of Spain and Ireland, we also had both countries had general elections where the vast majority of the public supported this austerity, supported the punishment of the poor. So do we really need to kind of draw back and speak a bit more about the normative content, what exactly is precisely meant by the international protection of economic and social rights? And then the second question, sorry if this is a bit nerdy, is there a danger in particular from, I suppose, Conor and Aoife's presentation of taking a very communitarian approach towards economic social rights and then a very individualised approach to civil and political rights? That's not what you may have been trying to get across, but it's something that I suppose I have been thinking that having a look at the kind of process and procedure of judicial, I suppose, the judiciary resolving issues relating to socio-economic rights seems to be in a very programmatic manner, as opposed to a clear, this is a violation of either the right to human dignity, right to health, etc. So they're just two questions.
Thanks, Liam. Is there any other questions? Well, we'll take those and we might come back. And so just to add to the first part of Liam's question, which was, should we draw back in terms of there's a political mandate for austerity, and talk about the normative content of the ESCR rights, what is meant. And perhaps in that we can just think about the next report to the Committee on Economic, Social and Cultural Rights, and what sort of information or data NGOs and human rights organisations can present. And is there a deficit in terms of the information, or is this just going to be rant? Are we just going to be saying things are awful? Are we going to be showing that things are in a certain way? And the second one is a very more of a philosophical question, Liam, if I may, in terms of a communitarian approach to the ESC rights and the individualistic. And this has traditionally been seen that way, as individualistic in terms of civil and political rights. And how do you bridge that gap?
I'm going to stick to the second question because, quite frankly, I'd have to think long and hard about the first question, Liam. You've caught me unawares in that one. I'm not sure I have an answer to that right now. I think the thing about an individualistic approach to civil and political rights is that, to an extent, an individualistic approach to that also deals with the communitarian aspect. So if one person complains about a statute limiting privacy or free speech and gets it struck down, that vindicates everyone's right to free speech or privacy in that one action, which is all very convenient, which doesn't work in the same way for economic and social rights. And I suppose partly what I was trying to hint at in my presentation is that the individualistic approach it's all very well and good to say every individual has this right to this minimum, but trying to enforce that through the courts, it is a bit of a blunt instrument. It is something the courts are quite uncomfortable with. And I think what we see in both the Irish and the South African context is whether the problem is because the overall policy is declared to be reasonable and tough luck for you, or because your rights have been breached but you can't get an effective remedy, you reach the same place, which is that some individuals don't get their rights vindicated. And I think that's kind of inevitable to an extent. I'm not sure there's a way to completely get around that. I think what you have to try and think about is what's the mechanism that minimises that to the greatest possible degree. Resources will always be scarce. Courts will always be uncomfortable and reluctant to get involved in this area. So I think you have to ask what's the most effective way of minimising the number of people who fall through the cracks. And I'm inclined to think that the most effective way to do that is the way that the courts are most comfortable with and are willing to use most expansively. And I'm inclined to think that the South African model lends itself a little more to that than our model, because ultimately, while they're reluctant to grant a remedy, when they do, they grant a proper one.
And I suppose I'd bring us beyond the South African example, and I'd say that there are countries that have much more established and actually long-standing economic and social rights bodies of case law that deal not just with the kind of systemic or broader issues, but also are prepared to find that there are minimum core obligations. An example would be Colombia, where, for instance, overall economic and social rights are to be progressed generally, over time. And you look at, say, the coverage of particular social and economic policies. But they said that when it comes to, say, pregnant women, older persons, people with disabilities, children, they have an immediate entitlement, which kind of brings in the individualistic element. And we do have to query that while we can turn around and say, well, these are, big issues and, they're cross-community, and when we're talking about positive obligations and the need for the state to take, positive measures, then it's going to have, it's going to be a different situation to where the state has to, strike down, deal with a negative obligation and, a struck down piece of legislation. But I suppose what I'd say is we also need to bear in mind that the point of economic and social rights fundamentally is that these are things we think are important that people should have. So we can't have a system where people are allowed to fall through the cracks in effect because government can turn around and say, well, actually, we're taking reasonable measures, but you know what? Yeah, the fact is, your community hasn't been provided with, say, adequate housing or adequate water. So there has to be a balance struck between having the rights, giving them meaning for the individual, but also meaning that they're kind of progressed and move forward in a more, across the community in a more progressive way. I suppose with regards to austerity, the alternative, I think that the fact that austerity, I don't think that there were votes in favour of austerity in Spain and Ireland. I think there was a lack to articulate an alternative. I think that one of the things that's very interesting is that we can see very clearly, and this is a failure of academics and rights advocates and politicians in the media, is to present that alternative. It also shows the lack of a rights culture, because if you start saying, oh, well, actually, I have an alternative economic, social and cultural rights-based approaches to economic crisis, you'll just get a what? So, I mean, that is down to us, that you don't just turn around in the morning and present something. It has to be, it's something that takes time. And I think that's what it indicates for, the lack of that culture that could have, a rights culture that could have led to that alternative, rather than everyone saying, actually, austerity, it's grand. It was just, I mean, think about the EU fiscal compact. People voted yes, because were we going to say no? So anyway.
And I might just finish on that last point around people's understanding of rights. Yes, this is a very interesting debate, but we really need to translate what those rights actually mean. We've been done some limited polling around public support for human rights and economic, social and cultural rights as opposed to civil and political rights. And yes, it shows high support, but we do wonder whether it's a bit motherhood and apple pie. Of course I support the right to health, You wonder about the people that strongly disagree with the right to health, but how do we drill that down, and how do we make the leap imaginatively and practically from your support for the right to health? How do you balance that with what's happening to you and your family around private health insurance, or you support the right to housing? What does that mean in terms of your experience around mortgage arrears, for example? So we need to link the human rights discourse to the discourse that people are having around their kitchen table. And I think that's the challenge for all of us, is that in some ways public education campaign to translate human rights standards out of human rights law textbooks.
Okay, I've just been informed they're finished. So I'm going to ask you all to stay for 10 more minutes for more questions, and you can't eat. No. We'll break now, and I'd just like firstly to say thank you very much, everyone, for attending. You've been excellent questions and response, and please join me in thanking the speakers.